The government thinks that Diddy's lawyers violated the protective order over the videos in the Diddy criminal case in their filing that I covered on stream on January 15th. That filing has since been stricken from the docket and has been resubmitted in a more redacted version. There was a fleet of filings from the government and a few orders from the court because of what Diddy's lawyers filed. Are they still fighting over whether or not the protective order should be modified? Yes. Diddy's lawyers put quite a lot of information in their filing, information that characterized the things they watched on videos that are subject to a protective order. The government is less than pleased. I imagine the victim is also less than pleased. And when I covered it on stream, the law nerds were for sure less than pleased. At the end of the day, the defense has said, hey, Your Honor, we've complied with the court's order. We have filed a substantially more redacted version, but we think it's unfair that we have to. And we think it's unfair that we have to because if we have to do that, the result will be an unfairly polluted jury pool manufactured by the government's misleading narrative and widely disseminated by the press. They say that their characterization of the evidence that they've reviewed is appropriate, that it should not be sealed, and that the court should evaluate when something is proper to be sealed and that public access reigns here. I disagree with the defense argument on this because the protective order, including the sealing order, is already in place. The defense, I think, has properly asked that that order be modified the way they want it to, and then the court gets to decide. But you can't file things not under seal that contradict the protective order when you ask to modify the protective order. You have to wait for the protective order to change. The defense says that the government reading of the protective order is too broad, and therefore they should be allowed to have their original docketed item stand without all of the redactions. We'll see what the court does with that. This is going to go to hearing probably in February, and we'll see if the court modifies the protective order then. We're going to have to wait and see. If the protective order is modified, it might not change the sealing order. If the protective order is modified, really the heart of what they were asking for is to allow them to have digital physical access to the videos at question. Here are 9 of the videos that have been identified. They want to be able to have those videos enhanced, for audio, shown to expert witnesses, evaluate the metadata, talk to other witnesses about them. They want access to those videos. Not just inspection of the videos. They want the videos to come to them instead of them going to the videos. And we'll see what the court does with that. But the court can do both. The court could say, yes, under protective order, you may have access to these videos, not just inspection, and the sealing order stands, you still can't put this in your filings. We will see what the court decides to do, probably in February. But again, when I say this trial is right around the corner in May, this trial's right around the corner in May. Dealing with digital experts is not a swift process, so I still don't think this will go to trial in May. I really don't. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.